Hello friends, welcome to Sriram's. The topic for today's discussion is All India Judicial Service. There is talk about setting up All India Judicial Service, so there is a need to know the why and what of it. What is subordinate judiciary and how is it appointed? Subordinate judiciary is the court system at the district level and below it. The subordinate judiciary is a state subject or an item in the state list or list 2. The appointment of members of the subordinate judiciary is made by the governor. Such appointment is to be made in case of district judge, in consultation with the High Court, and in case of other posts, in consultation with the Public Service Commission and the High Court. What is the background to the All India Judicial Service? There has been a suggestion for many decades that an All India Judicial Service or AIJS should be constituted. The idea for AIJS was first proposed by the 14th report of the Law Commission of India in 1958. Supreme Court endorsed it. Does the Constitution of India allow it? Article 312 deals with the All India Services. The 42nd Constitutional Amendment Act in 1976 inserted All India Judicial Service into the article. The Amendment Act says that the All India Judicial Service shall not include any post inferior to that of a district judge as defined in Article 236. How do we create an All India Service? The process of creation of All India Service begins when the Council of States or Rajya Sabha declares by resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in the national interest to do so. Following such a resolution, Parliament may by law provide for creation of an All India Judicial Service. The law of the Parliament to create AIJS is not deemed to be an amendment of the Constitution within the meaning of Article 368. Why was the 42nd Amendment necessary in that case? The 42nd Amendment amended Article 312 not to create an AIJS, but to mandate that the AIJS so created should be not less than a certain grade. That is, it shall include not any post inferior to that of a district judge. In sum, Article 312 Clause 1 allows Parliament to pass an act to provide for creation of an AIJS, while Article 312 Clause 3 says it should be only for judges above the level of a district judge. What are the advantages of AIJS? The advantages with AIJS are: the best talent at a young age can be tapped from all over the country. It fills up the existing vacancies at the level of district judges and also helps to fill the strength in high courts after the AIJS recruits become eligible, and thus there is a readily available pool to choose from. Thus, it is a beginning to remedy the vacancies challenge. The near uniform standards prevail in country in judicial matters. National integration, as in the case with the existing All India services such as the IAS, IPS and IFOS. It enables proportional representation to the vulnerable sections, including the economically weaker sections across the nation. What are the objections to the AIJS? 3 main objections are raised against the AIJS. First, inadequate knowledge of regional language would dampen judicial efficiency. Second, promotional opportunities of the members of the state judiciary would be severely hurt. Third, erosion of control of the High Court over subordinate judiciary would impair the independence of the judiciary. Are the objections maintainable? The objections have been answered effectively by, among others, the Law Commission. Learning the regional language has never been a problem, as seen in our experience with the IAS, IPS and IFOS. It also furthers cultural integration. With respect to the second objection, only a portion of the total vacancies are to be filled through the All India Competitive Examination, while the remaining are open to be filled by promotion from the lower cadres. Control of the High Court will remain as on the allotment of a state. The allottees, the members of the AIJS, would become members of the subordinate judicial system under the control of the state government and respective high courts for all practical purposes. Some states are opposed to it, saying that it will lead to centralization and erode federalism, but AIJS creates cooperative federalism. Some states want not more than 15 to 25% of the posts of district judges to be filled through AIJS and rest of the strength to be left for promotions. Do the states today select judges based on a competitive examination? At present, almost all states have a system of selecting members of subordinate judiciary, but there is no All India Judicial Service. Well, that's all for today. I hope you enjoyed today's podcast.